Hi, Andy. Thank you for joining us today. So we're going to discuss all things employment, more from an employee and an employer's perspective. And I think it's really to address some of the misconceptions people may have of what lawyers do in relation to employment issues. I know, speaking to other clients previously, they have this perception that you're always in the favour of the employer. And of course, when you speak to employers, they'll say, these contracts are worded too much in favour of employees. Given your experience, you've been doing this for many years now, what do you feel is the right balance between the parties and the main purpose of an employment contract?
Firstly, thanks for allowing me to join you today, Shiroz. Employment contract is to, and a lot of things, is to set the boundaries, set the ground rules, if you like. What an employer wants, what an employer expects, an employee in return, to determine what that is. But for me, and a lot of issues that I see stem for both employees and employers is a lack of communication. And I think it's absolutely key, despite what is maybe written in a contract or a handbook, it's how people behave.
Sure.
And employers being clear on what they expect, and employees, if they see something they don't like, raising it in a professional and proper manner.
Brilliant. So you and I, we've worked on a number of matters together, and I think it's important we touch on that because often clients and individuals alike don't appreciate the importance of what they're signing. Everyone's in good spirit at the start of joining a new position or employing a new individual, and many people probably, rightly or wrongly, don't read the finer print, sign documents, and 3 years down the line or whatever period decide to change or move or for whatever reason exit the business, or potentially in some instances that we've had to deal with, set up in competition. And the main point I'm touching on is restrictive covenants. How important are they? Where do you feel they're necessary or not? And of course, we've seen them enforced in action.
Yeah, so restrictive covenants are usually there to protect the employer and to protect their business and to protect their clients. And they are key for certain industries, sales being one, marketing, even for law firms. But the key with restrictions is that they don't overly restrict an individual, and there is a test usually dependent on the level of those individuals. If they are in a very, very senior position, they are able to be more restrictive.
Sure.
But perhaps for more junior or entry staff, a court will often take the view that they can't be as restrictive. It cannot stop people from pursuing a career. So for me, and advice for a lot of employers when they look at drafting restrictive covenants or subsequently down the line looking to enforce them, the key point for me is, look, what is the real value of this, and what are you looking to achieve? Because more often than not, it comes from bad blood and animosity, and people's emotions take over. Again, like I said to your previous question, as long as someone is managing their clients and their staff correctly, because often they're brought in to stop people taking clients, then an individual would not try and poach those individuals, because as a firm or a company, you have good relations with your clients, and you're able, that the restrictions won't bite, and there's a minimal risk of an individual leaving and poaching those clients.
No, that's very helpful. And I think it gives that overview to everyone, A, the importance, and B, the level of those restrictions, because we've both seen many instances where employers have prepared their own employment contracts and picked up boilerplate clauses that they assume can apply to, let's say, the most junior level right up until director, partner level. And of course, the implications or the broadness of those restrictions, it causes more issues than actual a resolution for the employer.
Absolutely. And the courts are really clear that, they need to be clear what it is. If there's any potential confusion, the likelihood of them being enforceable is significantly reduced. And like you said there, with clients, big risk, and a big mistake you always see is the restrictions referring to definitions, but the defined terms not being defined throughout the contract, and that is probably something you see quite regularly as well, and raises huge issues and makes them largely unenforceable.
No, brilliant. So I think another point is many, of course, employment lawyers, you see all the ins and outs of what's happening in businesses. The confidentiality element is far more important. And there'll be many businesses we all see, we walk past day to day, and they have, like any business, their fair share of internal issues that need to be dealt with. For many clients, they feel this is really expensive, going to a lawyer to get the advice. But having seen tribunal work, I know you do your own tribunal work and are often in the employment tribunal for clients, just to clarify. But the risk of not seeking that advice early doors, and I appreciate putting the cost to aside for a brief moment. There's many services. I know your team have the retainer service, but let's say many employers, they feel they've never had an issue and now it's one thing after another. What's your steer on that? How early should they be seeking that advice? And how important is it what they're saying and following due process?
Yeah, quite a lot to unpick there. But if I could take it at each point at a time. In terms of getting advice, it will obviously depend on the company. What support do they have? Do they have HR departments? What industry are they in? Are they in a professional environment or a factory environment where issues can sometimes arise? So really looking at the internal, but I think it is really important to get legal advice and certainly get support, because employees ultimately are a company's biggest asset.
Sure.
And they can give you the biggest headache as well. And that's why they say employment law is recession proof, because there's always those issues. So often than not, I will say to a client, and where issues really tend to come up is they will phone up and say, right, we want to get rid of this individual. He's been in trouble for years, or she, and right, we've had enough. Okay. So what have you done? Have you got evidence of having these conversations? Oh, yeah. And when it comes to it, the picture that they've told you, the story they've told you of this being a real problem employee isn't actually borne out with the evidence.
Yep.
And their appraisals to say they're good or excellent, and there's minimal emails or file notes. And when the individual gets approached, it comes largely out of the blue.
Yep.
And that is really just from a misunderstanding sometimes from employers in terms of how to manage process. And we would always say, look, as soon as you feel there may be an issue, approach it. Come up with a strategy. Come up with a roadmap. Given employment law, it isn't always easy to get from A to B without any bumps in the road. But how are we going to get to A to B? What will that look like? And having that advice and having that plan at an early stage sets people up really well, because they often think they've done those points. They feel that they're at the end, and in fact, they have a lot of steps that they still need to take, and then frustration, will come through, and prices will escalate.
Yeah, no. That's very helpful, and I think it mirrors that message of seeking the advice as early as possible. At least that way they've got a plan or a strategy of what does B, or how do we get to B, what's the journey look like. And like you say, it's going to have its ups and downs. It's very rare that the journey is just a complete smooth sailing process. And if you start the journey, you're going to struggle, really. There'll be many issues that can come to light, and you'd rather handle them or try to handle them as best as you can as early doors. I think another, in the current climate, key topic for many professional services or office-related roles is getting staff back to the office. It may be after COVID, the environment or the climate's changed somewhat. We often hear or see employers complaining that employees just aren't coming back. What's your view on this?
Hybrid working's here to stay, and I think COVID has accelerated the rise of hybrid working, and I think it's only going to expand and become I say more of a headache. Depends which way you look at it, but I think it's going to be something that people coming into the workplace are going to expect. Technology is going to accelerate it as well with AI, and I know we've touched on that, in our day-to-day work. Again, for employers, it's about having that grown-up conversation and understanding. Why are you asking people to come into work, and what are those parameters?
Yeah.
I 100% agree and support there being an office work, that people are in the office a certain amount of time, perhaps 2, maybe 3 days. I think it's really key for office, what I call office osmosis, that people can overhear conversations and what have you. And that hybrid working is something that's there, and I can speak as someone who benefits and sees the benefits from hybrid working. When I first had my son, who's now 10, I was working at the standard 9 till 5:30, dropping off at nursery at 7:45, picking him up at 6:30, 7 o'clock. Was not really something that you enjoyed, especially in the winter months. But now I have that flexibility, that I'm able to drop my son off at school, able to pick up from the school gates and manage my time accordingly. Still able to work. I'm not doing any less work. In fact, I'm probably doing more. But I also have that personal life that I can go and watch, like, sports days and what have you. And for employers, I think we really need to understand that wider picture, that benefit on both people's family lives, on their mental health, and again, have clear parameters on what is expected. It isn't about, and I've still not actually had a case that I thought I might do, of people saying, oh, they're at home, they're swinging the lead, they're not around. None of that. And I think if you're professional, you have good staff and people who are passionate about the cause, it is something that will actually help your business and grow your business and increase productivity.
Brilliant. I think it touches back on what you said from the outset. It's all about communication. It's about understanding people's needs, their personal lives as well as their professional lives. And as you rightfully point out, maybe even potentially playing devil's advocate here, 10 years ago, the level of seniority, the responsibilities you had probably were far different. I appreciate right now the osmosis element is probably you giving off the information to your team to absorb that information, take it on board. Of course, we all learn each and every single day, but 10 years ago, you're probably taking in a bit more from others around you. So I feel from an employee's perspective, as you rightfully say, many more will be saying, what are the terms? What do they look like? It's to realise what level of the journey you're on as well. How much do you need to develop in a certain area and take that on board as well as your surroundings? But I agree with you. It's very beneficial to have. It's important and allows that flexibility. But the key point being communication. Yeah. It can't be a micromanaging element which just won't assist anyone really.
Yeah. And as well, we come at it from a probably an easy situation as lawyers, in that the majority of the workforce on Monday to Friday, 9 to 5, and can work from home from the work that they do. Where I see some difficulties for employers, and I totally get it. We have clients there who have factory staff,
sure,
manufacturing staff, and the frustration for those, because obviously the people working on the shop floor need to be in the office, and they see management doing hybrid working. And that is a difficult situation, but it is something that people are managing through and working through. Some have it right, some not quite yet, and there is a bit of trial and error.
Like anything, it's continuously improving and adapting to the times. Now, without giving too much away, I guess, what's the current climate saying in the world of employment? Is there a hot topic that you're seeing appear in your email inbox more than before, or is there certain patterns that you're seeing and want to really tell employers and employees to look out for?
Real issue that we've seen really is about retention and recruitment of staff. That's for the last few years. And whilst it's often easy to point to COVID, but there does seem to have come from that. I think people's Um, Perceptions have changed, ambitions, goals, whatever it may be, have changed, and um, where people often, would put the work and really, really passionate. There is an element now of I want a bit of a personal life, and a lot of employees saying, "What can you do for me?" You see a lot of job interviews where it used to be, what can they do for us as an employer? It's very much, well, what are you offering me? Not just salary, but like individual benefits. There's a big part, again, from people coming into the workforce, and I think it's actually great. Environmental issues, charity issues, ESG matters. They're really keen. They want to know what you're doing as an employer and responsibility. And if it doesn't match their values, they just feel it's going to be another number. People will go. So we've seen a lot of the quiet quitting. We've seen difficulty in recruitment, and that's something that employers have really had to grapple with. I think coming down the track, we're going to see now with the new Labour government. There are a number of things, but the big one that at the moment they want to bring in is this right to switch off, which they have in other European countries. Now, I don't know how that's going to work. As a principle, fantastic, but in practicality, how is that going to work? And I can only speak from my personal experience. I'm one of those sad people who will check their emails every evening, first thing in the morning, the weekend, even when I go on holiday. That isn't to try and be better than anyone, or I don't trust anyone. It actually helps me relax to know what's coming in or what's awaiting me. Whereas other people, and I wish I was like that, are able to log off and switch off. So with this new proposed legislation, it's going to be really interesting how that works. Because as lawyers, as we get calls of an evening, we get calls at weekends, and I can't say to a client, well, I wouldn't say to a client, but how's that going to work? I'm sorry, I've clocked off at 6. You can't contact me. So I think that's going to be really, really interesting, and I think there is going to be a lot of issues that arise from that, but it's something that I think is going to come through. And the final thing is technology. I love to talk about AI, but that is going to, I think, change things hugely, not just in terms of productivity, but innovation. It's going to make people work harder, quicker. I think it's going to increase demands on people. So expectations are going to arise from clients and third parties, and I think it's how people embrace that. And again, as just speaking from a law firm point of view, in 3 to 5 years, I think our day-to-day lives and what we work and things will look hugely different. Once AI is, come into all our life.
No, I agree. I know you're very into AI, so to speak, in the keeping up to speed. You're always telling us what's going on and what new features are there, which is helpful. But I feel the risk with it as well is quite high. Many, and I'm seeing this myself now, litigants in person, which no doubt you see on the perspective of when they're employees and you're acting for the employer, produce documents or letters or correspondence, and you can very quickly make out that they are AI generated.
Yeah.
And they don't advance their position any further. Yes, they look, the layout's very nice and neat, and there's mention of correspondence and certain issues in there. But it causes further complications because, in my perspective, I may be speaking out of line to some degree, but going to court and having to present that is completely different to having a document where it has everything written down. I appreciate judges will have a sense of leniency towards litigants in person and allow them that extra time to relay their message. But at the same time, you have to understand what's being said. It's of no use to present documents and not being able to digest everything that's on there. And I feel many individuals may become lazy And what I mean by that is they'll send documents without proofreading and without understanding they are factually correct. And AI is continuously upgrading and changing. And we've seen of cases that have been reported, fortunately in the USA, I think, where case law has just been made up. It doesn't relate to what's being said.
Yeah.
So you do have to do the work for individuals. They can't just look to hide behind the screen of AI and off it goes, so to speak.
Absolutely, and interesting you bring up a case. I had one. I won't mention his name, but he is a serial litigant who is currently being looked into by HMRC. It's his job. He just goes around applying for jobs and then bringing a claim. Had a tribunal with him, and his witness statement listed all these claims. He openly admitted that he used AI to help him, which again I don't have a problem with as a general principle. But when you actually looked at the cases that he raised, they were all what we call first instance cases, where someone had won a claim for, he was bringing claims for disability discrimination. They had won at the employment tribunal, and he was saying, look at this case, that supports me. Missed the really important element of it actually gone to the Employment Appeal Tribunal and had been rescinded and kicked back. So it didn't support his case. Now, for me, that was great. It was an open goal. But I could say, well, look, this is just nonsense. And his witness statement went on and on and on. But it was clearly just one that he pulls out for every tribunal case. But again, looking at it from an employer perspective and people who come into the workplace, it will make them and it will help them, if it's used correctly, develop and learn. But it has to be about that checks and balances. Not taking what it says as the truth and doing your own due diligence on it.
And that's the key, because as you said about this individual, it leads to problems. And I appreciate him looking at the cost element, but the client or the party that is on the other side, there's more research going on, there's more costs involved, there's more digging out exactly what's happened. And if someone's just there putting in user information, so to speak, printing out generic documents, we have the duty to explore what's being said and determine, A, is it factually correct, and B, what the implications of this. Whereas, let's say, go back 6 years, if this litigant in person or whoever was, this was their role, i.e. bringing claims to try and settle, so to speak, they may not have access to that information so freely. And if they do, they won't be able to portray it in a manner where it comes across, where a client or a lay client may see it as quite articulate and think, maybe there's something in this when there isn't.
Yeah.
And it touches on a point that you mentioned of quiet quitting. I appreciate the two don't go hand in hand. But as an employment lawyer, you've probably seen countless settlement agreements. Appreciate that isn't the same as quiet quitting. But I just wanted to touch on that in this podcast as well, of the importance of A, the correct wording, and B, how settlement agreements can be very beneficial for all parties.
So settlement agreements, for those who may not be absolutely aware, it is effectively a drop hands, the previously called compromise agreements, for those who are old enough to remember those. And they are usually where there is some sort of dispute and positions have become quite entrenched, and they're usually as well, or more often than not, done for senior exits. If a chief executive is leaving or someone on the board, it makes sense for everyone to try and get things concluded. But it provides for an employer certainty, closure. They know if we pay X amount by X date, this individual could go, and they've got certain restrictions that they can't criticise us, can't use confidential information, and if they do, then we've got we've got the means to pursue them if needs be. But they are a good tool. It does need people to go and get independent legal advice, which people sometimes forget, or employers sometimes forget. But with those individuals, if there is a concern, it can alleviate matters quite quickly. And I use this term a lot. But we act mainly for employers, but we do act for employees also. And I've always said, a settlement agreement is tended to be used to avoid as well the employment tribunals. So the only winners of an employment tribunal are the lawyers, if they're all lawyers, because of the cost. Even individuals and managers and positions have become entrenched. I've said, look, you will not be inside a courtroom for 18 months, 2 years. This matter will have forgotten about. There'll be another issue or another project. Employees have got a new job. Look, let's get this settled now. I know positions and people are frustrated, but look, let's try and get this sorted. Let's get this ironed out. Because I could sit here and say, yeah, let's go into court with every single case, but that isn't beneficial for your company. So yeah, there's really good means for that.
Brilliant. Thank you, Andy. It's been very helpful. I think it's a very quick overview. There's a lot more we can always discuss, and I'm sure we'll have to. I really appreciate your time and talking all things employment with us.
Look forward to part 2.
Thank you.
Thank you.